Good afternoon, everybody. My name's Allison Poirier. I'm an attorney here at Kahan Kerensky Capossela in our estate planning and probate administration and real estate departments. Today, I'm going to be presenting to you on a topic of Medicaid eligibility, which if you tuned in about 2 weeks ago, Attorney Bill Dakin gave you some basic information in terms of when to start thinking about long-term care. So I'm kind of dovetailing in on some of the issues that he addressed in his webinar, but really focusing in on specifically Medicaid eligibility. So what do you have to do to be eligible, and kind of planning, some general planning tools on how to get there. So today's purpose is, or I should start off by saying, when we're talking about Medicaid eligibility, you have to have both a medical need and have to be financially needy as well, because Medicaid is a state welfare program. So it's designed to pay for long-term care for folks who don't have the funds to do so out of their own assets. So even though, again, today, to address just very briefly that you do have to have both a medical need as well as a financial need, today's focus is going to be more on how to become financially eligible for Medicaid. And Medicaid, too, is also called Title 19. So if I refer to one or the other, the terms are interchangeable. So the big takeaway for today is that long-term care is expensive. If you do need it, it costs a lot of money. If you need to go into a skilled nursing facility, or if you need to have kind of round-the-clock in-home caregivers, there is a very large price tag associated with that, which I'm sure comes as no surprise to anybody. So to give you estimated figures of the average nursing home care cost in Connecticut, so if you did have to go into a skilled nursing facility, the average cost per month is $13,512 every single month for that care. And that's the average cost. So that means there may be some that are a little bit less, there may be some that are more, but that's an average of what nursing home care costs in Connecticut. Also, the average stay for someone who goes into a nursing home in Connecticut is 32 months. So if you multiply 32 months by that $13,512 for the monthly cost, the total average cost of a nursing home stay, again, for that 32-month period, is going to be $432,384. So that is a very large number. So again, even for folks who have saved really well, have sizable retirement accounts, and have done a wonderful job investing during their life, they may not have sufficient funds to pay for long-term care, or it's going to really eat away at those assets. And also, too, that's just an average number. Some folks are going to spend less time in those nursing facilities or needing that level of care. Some people will spend more. So even if you say, well, I have sufficient assets to cover that, if you need care for a longer period of time than 32 months, if you need 3, 4, 5 years of care, you're going to see that number just grow exponentially. So there are ways to cover that cost. Again, if you have the funds to pay for it, wonderful. If you don't, there's also long-term care insurance, which could take off some of the burden of paying for those costs. But long-term care insurance, as Attorney Dakin mentioned in his seminar last week, can be fairly expensive, even if you do purchase it while you're younger and healthier. It just tends to be those premiums tend to be very expensive. So it may not be an option for a lot of people. So, and also too, I've heard a lot of people say, well, I have Medicare or I have health insurance, and that's great, but that doesn't cover long-term care costs. It may cover the first 100 days or so of that nursing home stay. But after that, that's when Medicare drops off. So just because you have health insurance or you have Medicare, that is not necessarily going to cover extended stays in a nursing home, or again, extended in-home care, need for in-home caregivers. So if you do run into the situation where, again, you're paying out of pocket and you're running out of funds, or at least right at the outset, you don't have the funds to pay for that level of care, that's when you can apply to Medicaid. Medicaid is a state program. Well, they'll come in and they'll pay for all of your long-term care costs, but you have to be eligible. And they say, really, they don't want you applying for Medicaid if you have other funds to pay for your own care. So the eligibility requirements are very strict. They say you can only have $1,600 worth of assets to your name. So really, again, they're looking for you to spend down any other asset that you might have before you come to them. So that's the asset test. There's also an income test too. And I'm going to get into some more of the specifics of those. But generally, the big number that a lot of people need to be aware of is that you can only have $1,600 in countable assets. So now breaking into what do I mean by countable asset? Well, that's any asset that you have essentially that's available to you that you can spend down, get money from, and use to pay for your care. But there's a few assets that are not going to be deemed to be countable assets. So there's certain assets that they say they're not going to count towards that $1,600 number. The number one is the house. If you are living in your house, if your spouse is living there, a disabled child is still living in your home, if any of those people are still living in the house is going to be considered an exempt asset. So it doesn't count towards that $1,600 mark. They're not going to force you to sell your home. That's the good news. And actually, they let you keep your house up to, you can have a maximum amount of equity in your house, and that maximum amount is $900,000. So you can almost have a $1 million house, and that's still not going to be counted towards your Medicaid eligibility, so long as, again, you, your spouse, or disabled child, or some other people in a very small class, designated class, are still living in the home. So there's also a few other non-countable assets. Your spouse can have a car, personal property items around the house, smaller life insurance policies are not going to be counted towards that $1,600 mark. But again, that list of non-countable assets is in the materials that I provided for you today. So if you want to see some of the other items that are on that list, please feel free to look. And again, I've just kind of listed off some of the more common ones there. Also, there's going to be, so there's a category of non-countable assets which don't count towards that $1,600 mark. There's another category of assets called inaccessible assets, which are assets that you have, but are not necessarily ones that you're going to be able to liquidate and then use the funds from sale of those to pay for your care. A really good example is one that I saw come up at our office a few years ago, where someone owned a house that was on one parcel of land, and then they owned a secondary parcel of land. But it was just a very small piece that the garage was sitting on that was attached to the house. So in this parcel, again, it was solely taken up pretty much by the garage. There was no road access and no other way to go across or to get to this other than crossing over that initial parcel that was owned by the applicant. So that we made the argument to the state that that second parcel, even though it's an additional asset, it's not one that can be sold, because it's not one that's going to have any value unless you're selling it with the house. So since their house was exempt and they weren't selling the house, they couldn't sell this other separate lot that just had their garage on it. So it's an inaccessible asset. So those are the first two categories. If your assets don't fall into either the non-countable category or inaccessible asset category, everything else then that you own is going to be deemed a countable asset. So all of those countable assets then are going to need to be sold down, or spent down, I should say, and spent on your care before you're going to be able to become eligible for Medicaid. When we're talking too about countable assets, it's important to note too, there's different rules for married couples. A lot of folks say, oh, okay, well, if I just need $1,600, I'm going to transfer everything to my spouse and then it'll be protected and I'll be eligible. It doesn't really work, because the state looks at married couples as a joint unit. So if anything that your spouse has or is available to your spouse is going to be counted towards your Medicaid eligibility too. So simply transferring assets between spouse isn't going to work and make you become eligible. You're still going to need to spend down a fair amount of those assets. And there's also, it's important to know that the state isn't going to make your spouse, if only you need the care, the state isn't going to impoverish your spouse and take every single penny that your spouse owns. There's still an amount of funds that the state allows your spouse to keep. And again, I'm going to go into that a little bit later on in my presentation, but generally keep in mind, married couples are viewed as a joint unit when the state is looking at Medicaid eligibility. So you can't just transfer everything to the spouse that doesn't need the care and then to make yourself eligible for Medicaid. Another big takeaway too is people see, they've gone to various presentations or seen the infomercial on TV that trusts are the solution to everything. If I have a trust, that'll protect all my assets too from Medicaid. And assets that are owned in trust may or may not be countable assets for when determining Medicaid eligibility. And that largely depends on the type of trust that it is. If it is a revocable trust, sometimes also referred to as a living trust, those types of trusts have no protection for long-term care assets or for assets when we're looking at Medicaid eligibility. If your house and bank accounts and brokerage accounts or those types of things are owned in a revocable trust, in a living trust, those are still accessible to you. Those are still going to be deemed countable assets that need to be spent down. So that's important to keep in mind. There's a second type of trust that's called an irrevocable trust, which, as the name implies, with the revocable trust, the living trust, you're free to change that and modify it during your lifetime, take assets in or take assets out and put assets in. That's why it's still deemed to be countable assets. With irrevocable trusts, they're essentially, once they're set up, you might as well consider them carved in stone because you can't rewrite the rules. You're likely not the trustee or the beneficiary. So really the purpose for a lot of folks in creating these irrevocable trusts is to separate themselves from these assets. They put their house or they put other assets in these irrevocable trusts. So that way they can make a valid argument to the state of, I don't own those assets anymore. I don't have access to them. I put this into this trust. I'm not in charge of the trust. I'm not a beneficiary of the trust. You can't force me to sell these assets because I don't own them anymore. So that is a planning tool we use for some folks, but it's one we think long and hard about before implementing, just because we don't want you to separate yourself from your assets if later in life you're going to need them. So to the extent we can pull out our crystal ball and see, are you likely going to need care down the road? And the closer you get to that point, things like a revocable trust may be an option, but not always. So again, we don't want to advise you to start giving away assets or separating yourself from your assets until we know there's a high likelihood you're going to need care. So irrevocable trust, again, may be a planning tool, but it's not necessarily a cure-all. Also, too, it's going to run afoul of the 5-year look back, which is something else I'm going to get into in a little bit more detail in a little bit. So again, trusts are an option. Revocable trusts aren't going to provide protection for your assets. Irrevocable trusts might, depending on the way you set it up and the time in which you do it. But again, I don't want a big takeaway here is that trusts aren't necessarily going to solve all your problems. So that's really what I wanted to provide in terms of that asset test, how you can own assets, what are going to be countable, non-countable, and inaccessible, et cetera, for Medicaid eligibility purposes. As I mentioned, there's also an income test. So the state only lets you have a certain amount of income and be eligible for Medicaid, but that's a test that's a lot easier to satisfy. The state basically says, whatever your income is, we are going to take all of it to pay towards that monthly cost of your nursing home care. So, but we let you keep a very small fraction of it. And that very small fraction is they let you keep $60 a month. So very small amount meant to pay for smaller things, haircuts, and odds and ends here and there that you might need. But essentially, that they're taking the vast majority of your income and applying it towards the nursing home or giving it over to the nursing home to pay for your care. And I should also say there's an exception too for wartime veterans. If you're a wartime veteran, they let you keep $150 a month. But for anyone else who's not, it is only $60 a month that they let you keep. So as I mentioned, so long as the total amount of your income is less than that total monthly cost of the nursing home, you're going to be eligible for Medicaid, because again, they just take the excess over that $60 and just apply it towards the cost of your nursing home each month. So even though there is an income test, it's one that's much easier to satisfy than the asset test. As I mentioned before, just because they make you only, or I should say only allow you to have the spouse that is applying or the individual that's applying for Medicaid is only allowed to have $1,600. If you're married, they don't want to impoverish your spouse. They still want to leave your spouse with enough assets for their care and for their future costs that they might have. So there is an amount that they let the spouse keep if only one spouse needs care. And a few terms that I might be throwing out here is applicant. So that's the person that's applying for Medicaid, or institutionalized spouse, kind of same thing there. The spouse that's going into the nursing home, and then the community spouse, the spouse that remains in the community, the spouse that does not need the care. So on the date the institutionalized spouse applies for Medicaid, the state takes a snapshot of what are all your assets and your spouse's assets as of that date that you are applying for Medicaid. And based off of that, they say then of that amount, the spouse is allowed to keep 1/2 of the marital assets up to a maximum of about a little over $130,000. So to kind of give you a hypothetical, if you and your spouse have $100,000, the spouse can keep $50,000 because 50% Again, spouse is allowed to keep 50% of the assets, or $130,000, up to a maximum of $130,000. In this case, half of the assets is less than $130,000. So 50% is the amount that they get to keep. They'll get to keep $50,000, plus the institutionalized spouse is going to keep $1,600. So if you have $100,000 worth of assets, you really only get to keep 51,600 assets, and you have to spend down the rest. So again, they don't make the spouse spend everything, but they still make you spend down a pretty good amount. Again, the most that they're going to let the spouse keep in terms of countable assets is just north of $130,000. They also let the spouse keep a certain amount of income. And this is important because if the spouse that's going into the nursing home has a higher income stream than the community spouse, it may be possible for the community spouse to keep a part of the institutionalized spouse's income. Again, because the state wants to make sure the community spouse's needs are being met. They want to make sure that community spouse has enough money to pay their rent, to pay their mortgage, to pay for utilities, to pay for other costs that they might have. So if the spouse, for example, needs, let's say they're to pay for all of those things that the spouse needs, they need $1,700 a month. But the spouse only has $700 a month of their own income coming in. That means that they could potentially keep $1,000 worth of the institutionalized spouse's income, again, to make sure they're meeting those needs. So even though I said before, most of the institutionalized spouse's income is going to be directed to pay directly for their care, again, if the community spouse needs additional income to meet their monthly needs, you might be able to preserve some of that income, transfer it over to the community spouse. So that way they'll still have plenty of funds to meet their needs. And there is maximums and minimums there too, just as I was discussing before with the assets that the state lets the spouse keep. But again, it's the whole idea is that they don't want to impoverish the spouse that doesn't need the care. They still want to make sure there's enough funds there. To the extent you have them, they're going to preserve some of those for the community spouse. I should mention a few times here, I've mentioned both nursing homes and in-home care. There are different programs and different eligibility requirements for in-home care. So there's different asset and income tests. Today, I'm focusing primarily on if you need to go into a skilled nursing facility, but just be aware there are certain programs that are qualified under Medicaid where they provide in-home caregivers, not necessarily 24 hours a day, but they do provide some level of in-home care. And again, those have their own eligibility requirements. So it's important to kind of be aware of that. And if that's something that you're more interested in, is to meet with your estate planning attorney and figure out what those numbers are. And again, kind of figure out the best way to become eligible for those if you aren't already. The biggest thing that most people have heard of when we're talking about long-term care, when we're talking about Medicaid eligibility, is the 5-year look back. And what that is when you apply for Medicaid, the state looks at your last 5 years worth of financial statements to figure out where the money went. They want to figure out, did you actually spend down all your money on your care? Is there anything left? So they make you give them every monthly bank statement of every bank account you've owned for the last 5 years, quarterly statements for IRAs and 401ks, information on life insurance policies you had or currently have, information on real estate. They look at any asset that you've owned in the last 5 years. And again, they're tracking where that money has gone to make sure you really spent it down properly and to make sure you are in fact eligible for Medicaid. Because the thing that they're looking for is they want to make sure you didn't gift away all of your assets and then come to the state claiming to be penniless and say, here, I don't have any money, pay for my care. So to the extent you've made any gifts from within that 5-year period from the date of application, if you have, there's going to be a penalty period. They are going to penalize you for making the gift. And by penalty, I mean, they're going to say you're ineligible for a certain period of time to receive Medicaid benefits. So even if you're in the nursing home and you've run out of money and you can't pay them, the state says, well, we're not paying them either. You're ineligible. And again, for that period of time. And that period of time is going to depend on the value of the gift that you made. The larger the value of the gift, the larger the period, the longer the period of ineligibility. And it's also important to note that if a gift occurs at any point within that 5-year period, that period of ineligibility starts at the moment of the date you were otherwise eligible for Medicaid. So let's say June 1st, you submit your application to the state. They say, as of June 1st, you are eligible for Medicaid. or would have been if you hadn't made that gift 2 years ago. So your period of eligibility starts as of June 1st. So that month or whatever period of time it is that they say you're going to be ineligible, they start that running from the date you would have otherwise been eligible for Medicaid, not from the date of the gift that you made. So even if you made it for that gift 4 years and 11 months ago, that's not when they start the period of ineligibility. They start the period of ineligibility from the date you would have otherwise been eligible for Medicaid. Another big thing people run afoul of is not understanding kind of how the gift tax system and Medicaid eligibility interact. A lot of people have heard of this annual gift exclusion of $15,000 per year. So you can give $15,000 per year per person without incurring any type of gift tax and without having to file any gift tax requirements. And that's wonderful. If you're able to do that for your loved one, that's a wonderful thing to do. But also be aware that just because the state and the government are saying you don't owe a gift tax, that doesn't mean it's not going to impact you for Medicaid eligibility period purposes. They're still going to say if you made a gift within 5 years of applying for Medicaid, whether it was subject to the gift tax or not, we're still going to penalize you for Medicaid eligibility purposes. So just be very aware of that. That's one I hear all the time of, well, I heard it was okay so long as I give less than $15,000. And that's only true for gift taxes. That means you don't owe a gift tax, but it means you're still going to incur a penalty period for Medicaid eligibility. So if you do want to make gifts of your assets, if that's one of the planning tools that you want to use in order to preserve some of your assets, you need to do that sooner rather than later. And again, in the intent of trying to get those gifts outside of that 5-year window. Because if you gifted $1 million to the kids, but it's 5 years and 1 month later that you're applying for Medicaid, you're fine. There's no penalty because you're outside of that 5-year window. Regardless of the size of the gift, if it's outside of that 5-year window, you're okay. It's only if, again, your gift and it's within that 5-year window that you're going to run into problems. There is a way to cure that. So if you did make a gift to the kids with the intent of saying, I'm going to try really hard to get this outside the 5-year window, and then, oh, shucks, you know what, 3 years later, I need to apply for Medicaid, you can cure it by having the kids give it back to you. So if you get them the money back or the house back or whatever it is that you gifted, and then again, spend that down on your care, then you're still fine. You can still become eligible. So there are ways that you could potentially fix that. So even if you gift and it doesn't work, as long as everybody's on the same page and you can get it back, you may still be okay for Medicaid eligibility purposes. There's also some exceptions where even if you gift within the 5-year period, the state is not going to penalize you for. I'm going to stick with these hypotheticals that are examples that I'm going to give you with real estate, because that tends to be a really common one as people want to preserve their home. That's what they'd always envisioned passing on to the next generation or passing on to their beneficiaries. So there's certain exceptions that the state allows you to gift your home to certain people, even if it's within that 5-year period, and they're not going to penalize you. So giving them your house to children, a disabled child, or a big one we see that's a specified exception is known as the child caregiver exception. If your child moved into your house and was taking care of you, but for their care, their care was the only thing that kept you out of the nursing home, because they were there every day and helping you bathe and taking you to doctor's appointments and making your meals and getting you into bed every night. If it was only because of that you weren't in the nursing home, and they were doing that for at least 2 years prior to you going into the nursing home, then you're able to then transfer the home to that child caregiver again, even if it's 1 day before you go in or applying for Medicaid, because that's a specified exception to that gifting within the 5-year look-back period. So there are ways that you can gift, but again, the goal is to try to do it more than 5 years from the date you apply for Medicaid. And then otherwise, other than gifting, it's really, again, it's spending down. If you have more than $1,600 worth of assets, you have to spend down those assets to become eligible and get down to that $1,600 number. So when you're doing the spend down, there's certain things that it's going to make sense to spend down on. Some of the big ones that we recommend is paying off the mortgage on the house, paying off the loans on the car. You have credit card debt, spend that down too. Spend it down on bills that you're not going to want to burden your spouse with. If they're still staying in the house, wouldn't it be great if they're going to have this reduced income because now the nursing home may be taking a good chunk for all of yours. At least now they don't have to worry about paying the mortgage or paying down these other debts. So that's something that typically makes a lot of sense to spend down your money on. And again, when I say spend down too, this is the state's term for, as long as you're spending down the money or spending the money on yourself for something that benefits you, that's fine. So regardless of what that means, as long as you're spending it on something, again, for you, for your benefit, that's fine. So paying off the mortgage, paying off those debts. If you want to renovate the house and say, oh gosh, we've always wanted granite countertops in the kitchen, or you know what, it would make a lot of sense to make the bathroom handicapped accessible if I'm going to try to stay in the house. All of those things you can do. And again, you're sheltering that money that you would otherwise have to spend down essentially in the equity of your home. You're putting more equity in your home. And again, because the state says your house is excluded, again, so long as somebody's living there that's in the approved category, and the equity of your house is below $900,000, that's all protected. So it's kind of another method of preserving assets. It is retrofitting or renovating the home to increase its value or to make it more, just flat out more functional for you or for your spouse. There's also ways to convert assets into an income stream. So as I mentioned before, there's the income test and there's an asset test. The asset test is a little bit stricter because again, they really don't want you to have any assets if you're applying for Medicaid. But when we're looking at the surviving spouse, if we want to try to preserve more assets for them, one possible way to do that is to convert an asset. So let's say a survivor or the community spouse's IRA or 401k that they have it's an asset. It's funds that are sitting in an account. We can convert that potentially into an income stream by cashing in that account. And again, you'll have to pay the tax bill if it's an IRA or 401k or other qualified retirement account. But then you can use those funds to purchase a very specific type of annuity that is now going to give you payments every month or every quarter, however you structure it. And now we've turned that asset into an income stream. So we've taken it out of that pool of assets that now needs to be spent down because it's income. It's not an asset, so it's subject to different rules. I want to make you very aware that this is not just any annuity that you can do. It's a very specific type of annuity. So don't say, go to your financial advisor and say, Allison told me to buy an annuity and I would protect this money from long-term care costs. Again, it's a very specific type of annuity that you're purchasing. So just be aware of that. And it doesn't necessarily work for everybody too. But again, it is a possible planning tool out there that may work for some folks. So again, it's something that we see sometimes when, again, people are trying to become eligible for Medicaid, but also not spend down every single penny that they have. And last, again, you can do gifts, you can do transfers to irrevocable trust. Those things work. But with both of those, we're worried still about the 5-year look back. So before, when I mentioned that, I talked a little bit about irrevocable trust, how that might be a possible solution, but it's important to keep in mind, even if that's something that is a setup that does make sense and will help you preserve assets, and it's a structure that you're comfortable with, you still have to transfer assets into that trust more than 5 years before you apply for Medicaid. Because as far as the state is concerned, that's still a gift. You're gifting assets away that you would have otherwise been able to spend down on your care. So you still have to make those transfers into trust more than 5 years from the date you apply. So something we see, even if a lot of folks set up these types of irrevocable trusts and they transfer a life insurance policy in there, or they transfer their home in there, they make that transfer more than 5 years from the date they apply for Medicaid. Wonderful. You're outside of that 5-year window. You've preserved that asset. But then after that initial transfer of assets into the irrevocable trust, they say, oh, well, every month or every year, I'm going to put a little extra money in there to pay for the upkeep on the house and to pay the property taxes and the insurance. Each time you make that new deposit of funds into that trust, you're restarting another 5-year clock because you've just made another gift. So again, it can be a structure that works for folks, but you've got to make sure you set it up properly. So again, it's something that you really need to give a lot of thought with, meet with an estate planning attorney such as myself, and really walk through the motions to make sure you understand what it entails and make sure it's something that makes sense for you. So that's the presentation that I have for today. As you can see, there's a lot that goes into Medicaid eligibility. There's lots of rules and restrictions to be abided by to get you to the point where you're going to be eligible should you need that. those benefits from the state. So I highly recommend, if this is something that you have more questions on, if you want to see how the rules apply to your specific situation, please call us, schedule an appointment. We're more than happy to come in and have you come in and meet with us and really walk you through the details of a lot of these rules. Just because, again, today I kind of gave you the general overview. It would be very easy to do a presentation on this topic that lasts 3 or 4 more hours, just because there is a lot in here. There's a lot to unpack. So again, if this is something that you think you're going to need, or at least something you want to gather more information on, please contact us, and we're happy again to meet with you and really walk through those rules for you and give you the information that you're going to need to make educated decisions and maybe even start implementing a plan for you. So that's all for my presentation today. Again, my name is Attorney Allison Poirier. I highly encourage you to visit our website. We have some good articles that are already on the website about long-term care. And again, you'll have all of our contact information there. So if you did want to reach out and schedule an appointment, you're going to be able to do so through our website. And also, we're going to have another webinar coming up in 2 weeks. So if you have any interest, all the information about those upcoming webinars are coming up, or are going to be on our website too. So please check out our website, www.kkc-law.com, for more information. Thank you very much.